also hearing the appeals of HA, RA and OA against Secretary of State for the Home Department.
Yes, Mr. Mazzini.
Thank you, my Lord. My Lord, before I deal with the rehabilitation and serious offending and disposal, there are three short matters that need to be addressed. Firstly, in relation to the issue of the anonymity, we have prepared written submissions which we are going to send to the court in electronic form. We're happy, if you want hard copies as well, to provide those, but otherwise, bearing in mind that there is the Secretary of State neutral on the issue, we'll send those written submissions in, which I think will be today. Will be at some point today, so you'll have those.
Oh, thank you.
Secondly,
did you take into account in your submissions that in the Unuani case, the Strasbourg court obviously named Mr. Unuani, but it anonymised his children? It's a very similar case to this. A father, minor children, and he's named, but the children aren't, and the judgment's drafted in such a way as to avoid giving details about where they live or schools they attend, that kind of thing.
Well, my Lord, we have addressed that. We've recognised it, and you'll see what we say. Secondly, a case has come to our attention in the upper tribunal, prepared by Mr. Justice Lane, the President, and it focuses on the issue of seriousness of offending, which is obviously one of the issues in this case. Essentially, it applies what is said by Lord Justice Underhill and gives a little bit more explanation. And if the court are willing to accept that, we've sent that on electronically. I do have hard copies here if the court wishes me to hand them up now, but I'll simply...
Not unless you're going to refer to it.
I'll just simply refer to the relevant paragraphs, and then you can look at that in due course.
Yes. And you've given Counsel for the Home Secretary a copy?
Yesterday, my Lord, yes. And finally, before I forget, I referred yesterday to the case of AB Jamaica in terms of the court's approach to the meaning of genuine and subsisting relationship, but I don't believe I gave you the citation in the electronic file. It's at 1362, and the particular page number is 1381. And it chimes with what this court has suggested, that each case turns on its own facts, essentially. My Lords, dealing with the question of very compelling circumstances, and in particular the issue of rehabilitation, the point we make is a fairly simple one. The legal error that has been contended by the appellant is not a wholesale attack on the approach to rehabilitation. It's pretty narrow, and that's all I intend to deal with. At page 363, the Court of Appeal, paragraphs 132 through to paragraph 140, which is at page 366, basically set out case law. And we say they do that correctly. To paragraph 141 at page 366, they summarise the position. What those authorities seem to me to establish is that the fact that a potential deportee has shown positive evidence of rehabilitation and thus of a reduced risk of reoffending cannot be excluded from the overall proportionality exercise. The authorities say so, and it must be right in principle in view of the holistic nature of that exercise. Where a tribunal is able to make an assessment that a foreign criminal is unlikely to offend, that is a factor which can carry some weight. And then it goes on to talk about the fact it will rarely carry a great deal of weight, and so on and so forth, but nevertheless it is material. And the difficulty that the appellant has with what he says at paragraph 142, That summary may come to much the same thing in practice as the UT's proposition that no material weight ordinary falls to be given to rehabilitation in the proportionally balance, but I think with respect that it is more accurately expressed, and I cannot in any event adopt its reasoning that rehabilitation will normally do no more than show that the individual has returned to the place where society expects him to be, notwithstanding its endorsement in Buga. I do not think that it properly reflects the reason why rehabilitation is in principle relevant in this context, which is that it goes to reduce one element in the weight of the public interest in deportation, which forms one side of the proportionality balance. My Lord, we simply say that is right. The explanation there, it does what it should do, it's taken into account, it reduces one element, and it's relevant, has its materiality in the particular case. My Lord, I don't have anything to say any more on that matter unless there's anything else that the court wishes to discuss on that particular point.
Well, I don't know how much we may need, whether we need to go into it at all in this case, but it is noticeable in this case and in other cases that the Court of Appeal is placing a great deal of weight on the idea that maintaining public confidence is an important aspect of the public interest in cases of this kind. And they're not taking that from Hesham Ali because they appreciate that Lord Wilson's views were not endorsed by the majority and indeed were contradicted by Lord Kerr. But they are taking it from what he previously said as a member of a Court of Appeal and in the Serbia, I think it is, and treating it as established Court of Appeal jurisprudence. And the problem with it is that it's not a legitimate aim within the scope of the Strasbourg jurisprudence to date, which is focused rather on the prevention of disorder and crime. And it is an idea that maybe needs rather more analysis than it's been given. I mean, it rests on a sort of gut reaction that people think that foreign criminals ought to be deported. And most people, if you ask them, would say that. Most people don't realise that foreign criminals include people born in this country who've lived here all their lives. And they may not realise the sort of offences that trigger the relevant provisions. I mean, it's a rather unexamined sort of headline. At some point or other, we may need to look at that. It may not be that maybe this isn't the case where that's necessary.
Well, my Lord, yes, I think I have to agree with everything that you've said. But I don't think this is the case to deal with it. It hasn't been dealt with in any way below. And there may really be no difficulty in its application in any event, because a decision maker would look at it, as your Lordship says, someone who's committed a crime of, where they've got 12 months as opposed to someone who's got 10 years. In those cases, it's quite clear that even members of the public are going to look at those very, very differently. It's fact sensitive. But in any event, in this case, the point really is that in terms of one of the elements of the public interest, the individual is entitled for that to be taken into account if it reduces one element of the public interest in respect of deportation. And in this case, it is the question of reoffending in the future. So it is material, because I think in any event, if you take a public interest, even if you take a deterrent case, there will be cases where the issue of deterrence will be very different from other cases. So the public interest will vary depending on the particular facts of the case. And as long as the decision maker weighs that into the balance and takes account of all material factors, then we say they probably can't go too wrong.
Mm-hmm. Yes, thank you.
My Lords, the next issue is the seriousness of offending, and we set out our position at page 265. Essentially, there is no dispute that when considering very compelling circumstances, a tribunal must take into account the nature and seriousness of the offence. Further, the strength of the public interest cuts both ways. The more serious offence, the greater the public interest, and vice versa. The Court of Appeal in HNRA did not suggest otherwise, and if one looks to what they say about this, it begins at page 351. Paragraph 91 and 92, they look at the jurisprudence and so on and so forth. And at paragraph 94, they summarise their position as follows. 4 or 5 lines down, the tribunal is of course right that the offences are serious for the reasons which it gives, but their seriousness is reflected in the sentence which the court imposed, generally for the purpose of the proportionality balance. That falls to be struck in a deportation case. The seriousness of the relevant offending is established by the level of the sentence. See the case of Suku. It is true that this court has since made it clear that this is not an absolute rule, to the extent that a tribunal may be entitled to take into account aggravating or mitigating factors, but I do not think that that qualification has any relevance to the present case. And we say that the Court of Appeal directed itself wholly correctly based on authority and based on the particular facts of the cases that they were dealing with. The case of Polly Gordon, which I spoke of earlier, I'd refer this court to paragraphs 33 to 35. It's helpful in where Mr. Justice Lane explains his understanding of what is said by Lord Justice Underhill here, and he develops it slightly in terms of why what is said must be right and the potential pitfalls if this approach is not followed. For example, he makes the obvious comment that you end up in a situation where people who may have got just over 4 years would then be in a situation where you'd be discounting it and they would fall under the 4-year. And then how would a tribunal deal with that? But it's there, and I would ask your lordships to have a brief look at it. It's quite helpful.
The reference again, please.
It is Gordon, Deportation Sentencing Discounts, 2021, and that's the UKUT 00287 IAC. I do have a hard copy if you want to see it now, but electronic copies have been sent.
Thank you very much.
Thank
you. My Lords, that brings me to the...
Well, if you're moving on, what do you say about the point raised yesterday that Suku is incorrectly cited? I think it was that case, because it refers to the nature of the crime as well, as indeed as I think Unuwani, if I remember, referred to drug offences being particularly serious, for example. So are we just is that saying that you just ignore the nature of the offence and just look at the length of the sentence?
Well,
that can't be right, can it?
No, but I think that's why they make the point that you can look at, the Lord Justice Hunter makes the point that you can look at mitigating circumstances and aggravating circumstances, but you generally are not going to need to do so. But if there is something about the case that a decision maker that thinks is particularly important, then they can do so. But as I think what the case of Polly Gordon makes clear, if a court is going to do that, it needs to explain why in this particular case it is going beyond the actual sentence itself. So it's not a rule which is has to be followed in every case at all. It's just that is the general position, and if you're going to go behind that, then of course you can do so, providing you give reasons. But there are huge dangers inherent in a first-tier tribunal judge doing so, because it's the criminal court who heard the evidence, who took into account all material matters as far as they saw it, and gave the sentence based on that. So whilst the first-tier tribunal are not prevented from going beyond that, they need to be very careful in doing so. And I think that's the point that's being made, and the point that's being made in these cases, that when you've got these in HA and RA, one sentence of 18 months and one of 12 months, and they're pretty straightforward, there would be no reason to go beyond that. And if you were going to mitigate or look for exaggerated features, then you need to explain exactly what they are and why you are doing so. And I think in Unani, the point they make there is that the court has taken a particular view to certain types of cases, and I think they give examples of sexual assault and serious drugs, violence and so on. These aren't these types of cases. And they shouldn't be, that approach shouldn't apply to these lower-end, run-of-the-mill convictions. My Lords, if I can now deal with disposal. In the case of RA, for reasons that will become apparent, we say that RA must be remitted back for further consideration on all matters. The Court of Appeal found material errors in all three scenarios that it had to consider, namely the go scenario and the stay scenario relating to the unduly harsh test, and thirdly, the very compelling circumstances test. And we say that such errors, either on their own or in combination, mean there must be remittal. Firstly, looking at the go scenario, at page 356, so the court were looking to see whether it would be unduly harsh, the approach to unduly harsh, if the wife and the daughter were to relocate to Iraq. And they refer to the ground, the upper tribunal erred in failing to take account alternatively adequate account of material factors in concluding that it would not be unduly harsh for the appellant's child and partner to relocate to Iraq, with the appellant including, but not limited to, A, the importance of the child's British citizenship, the FCO advice against travel to Iraq, and C, the situation facing the appellant and his family on return. And we'll see that they agreed in relation to paragraphs A and paragraphs C.
Sorry, you're reading from
page 356.
356, thank you.
Paragraph 111.
But is this aspect of the decision challenged, the Court of Appeal decision?
No, and that's why it's important. It's particularly important. So, what the tribunal, the Court of Appeal say 113 is in effectively 114. They agree that the question of the child's British citizenship has not been given the importance that it deserves, and particularly in what they would describe as a borderline case. And we see at page 359, bottom of paragraph 114, as Lord Hodge makes clear in Zumbas, in any case involving the welfare of a child, a close scrutiny of all the substantially relevant considerations is required. At paragraph 115 and 116, the Court of Appeal do not accept the submissions of the Secretary of State in relation to British citizenship having been dealt with appropriately. So that was the first point they found an error on, and that hasn't been challenged. The second point can be found at the bottom of page 359, paragraph 118. And they say this: the country guidance does raise concerns about access to accommodation and employment for relocating Kurds who do not have family support. In particular, there is a finding that 70% of Kurds who are originally from outside the IKR are unemployed. Mr. Bazzini submitted that if RA was unable to secure proper accommodation or work so that the family became effectively destitute, that would have a very serious impact on the child's welfare. He pointed out that those issues are only referred to in the most general terms, and the essence of element C under this ground is the situation facing RA and his family on return is simply not adequately dealt with. So at paragraph 119, the court says, taking elements A and C together, I've come to the conclusion that UT's conclusion in this part of its decision is indeed not sufficiently reasoned. Economy in giving reasons is generally a virtue, but as I've said, what is required depends on the case. The tribunal's conclusion was that it would not be unduly harsh for a child of 5 to be removed to the IKR in circumstances where she would lose for the rest of her childhood at least the benefits of being a British citizen, and where there were, on the evidence, real concerns about RA's ability to find decent accommodation and a job. Such a conclusion required, in my view, a full explanation, which demonstrated that all material considerations had indeed been fully taken into account. Now, it's absolutely right. The Secretary of State does not challenge this. The consequences are that, subject to what a tribunal would find having gone back on this particular issue, it may well feed in not only to the very compelling circumstances test, but also the unduly harsh test. My Lords, I take you to page 331, where the Court of Appeal summarise or take extracts out of what is said in NA Pakistan. This is at page 331, paragraph 33, and they quote, the phrase used in section 117C6, and which we have held to be read in section 117C, does not mean that a foreign criminal facing deportation is altogether disentitled from seeking to rely on matters falling within the scope of the circumstances described in exceptions 1 and 2, when seeking to contend that there are very compelling circumstances over and above those described in exceptions 1 and 2. Foreign criminal is entitled to rely upon such matters, but he would need to be able to point to features of this kind mentioned in sections 1 or 2, or features falling outside those circumstances described in those sections and those paragraphs which made his claim based on Article 8 especially strong. That passage is expressed to cover the case of both serious and medium offenders. At paragraph 32, the court specifically addresses the case of medium offenders as follows. In the case of medium offenders, if all potential deportee could advance in support of his Article 8 claim was a near miss case, in which he fell short of bringing himself with exception 1 or 2, it would not be possible to say that he had shown that there were very compelling circumstances over and above those described in exceptions 1 and 2. He would need to have a far stronger case than by reference to the interests protected by Article 8 to bring himself within that fallback protection. But again, in principle, there may be cases in which such an offender can say the features of his case of the kind described in exceptions 1 and 2 have such great force for Article 8 purposes that they do constitute such very compelling circumstances, whether taken by themselves or in conjunction with other factors relevant to Article 8, but not falling in the factors described in sections 1 and 2. The decision maker, be it the Secretary of State or a tribunal, must look at all the matters relied on collectively in order to determine the position. And he goes on at the top of page 332, Lord Justice Underhill says this: those two passages make clear that in carrying out the full proportionality assessment which is necessary where the exceptions do not apply, facts and matters that were relevant to the assessment of whether either exception applied are not exhausted if the conclusion is that they do not. They remain relevant to the overall assessment and could be sufficient to outweigh the public interest in deportation, either if especially strong by themselves or in combination with other factors. And so the point that we make is that the go scenario needs to be determined. At the moment, it has not been determined lawfully. If it goes back and the tribunal find, for example, that firstly, RA is going to be destitute. He's not going to have a roof over his head. He's going to be living in poverty. But that is a matter they can take into account when considering very compelling circumstances, particularly in the context of him coming to the UK as a 14-year-old boy, in the context, obviously, of his family, and in the context of the best interests of his child. In addition, when looking at very compelling circumstances, they will look at features such as, well, if Dad is destitute and living in poverty, how is he in reality going to have contact with his child? How a visit's going to be realistic? And then, of course, I refer, for your lordships, to what Lord Justice Peter Jackson said about emotional harm. The impact on the child from knowing that not only has Dad been taken away from her, but that he is living in very severe circumstances that will have an impact on the child. So we say that the fact that the go scenario hasn't been determined and the fact that all relevant factors need to be considered, and these are very weighty material factors, they can clearly feed in to the very compelling circumstances test. And therefore, this case must be remitted back. But interestingly, on the particular facts, if those are shown to be the case, they would also impact on the unduly harsh test in relation to the child staying. Because in that case, one's looking at the best interest of the child, one's looking at the impact on the child, and again, the fact that a child is going to have very little contact with a primary carer now because he's destitute or living in poverty, the fact, again, the emotional harm to the child. It's quite one thing to think that my dad is living in a country where he's got a job, he's living in nice conditions, there are no real issues. It's quite another for the child to be concerned and extremely worried the whole time because of her parents' particular situation. So we say that the fact that the Secretary of State has not challenged the go scenario and the fact that it needs to be determined and it can and is relevant to both the VCC test and the stay scenario test. So for that reason, if none other, this case must go back to the upper tribunal to be further considered. My Lords, the second matter that the Court of Appeal deal with is the stay scenario itself, and that can be found at page 360. At paragraph 121, Lord Justice Underhill says this: I can take this aspect more shortly. I have set out the entirety of the UT's reasoning on the issue of whether if KI and Y stayed in the UK, the effect on them, and more particularly on Y as a 5-year-old child, of RA's deportation would be unduly harsh. Mr. Bazzini submitted it was unclear from the reasoning what factors had been taken into account in considering the issue of undue harshness, and that made it impossible to see whether the best interests of Y had indeed been treated as a primary consideration. I have to say that I believe this is a fair criticism. Paragraphs 58 to 60 of the decision do not, in my view, amount to the kind of particularised consideration that it is clear from Zumbas is necessary in a case of this kind. My Lord, I won't take you to it, but I remind you looking at Zumbas, page 1322, particularly the legal principles 5 and 6.
Doesn't a tribunal have to have evidence presented to it in order to deal with these issues? And just to merely say that the father has always been a very involved father, it hardly addresses the level of contact and the various issues referred to.
My Lord, we don't accept, in terms of the evaluative exercise that the tribunal had to take on this, that was the only evidence.
Well, perhaps you can show us other evidence then that you adduced in the tribunal.
Well,
that they didn't take into account. Well, because at the moment it just seems to be a general point that they didn't have much particularity, but they've only got what they've got.
Well, they have, but as I think the tribunal, the court will make the point, the essence of the evidence was that the father was fully involved with the child's life. And as such, there would be serious emotional harm impacted upon that child, and the child would suffer greatly. The thing about it is that, as both, I think, Lord Justice Peter...
Sorry, I'm sorry for interrupting, but was evidence led as to the involvement of the father with this child?
Only insofar as we've seen that the father was involved in every way in the child's life, as any father would be.
The only bit of evidence that I've come across is his witness statement, where he says that he's always been a very involved father. Doesn't tell you very much.
My Lord, I accept it. It tells you what it tells you, and no more.
And was there any other evidence apart from that?
My Lord, no. Other than the normal evidence of a father devoted to his child, with the child throughout its life.
How do we know he's devoted to his child? How do we know that he was throughout his life? How do we know what sort of contact he had with the child?
Well, I don't think there was any dispute that he had always lived with his child from birth, and the only time that he was apart was the 6 months that he spent in prison.
Well, there are many people who live with their children from birth who don't make much of a contribution.
My Lord, that's right, but that's not suggested here. In fact, what the tribunal found, and in fact both Lord Peter Jackson and Lord Justice Underhill make the point. So the point is made at page 356, just halfway down, where it's stated, I should note that although the tribunal says at paragraph 65 that has already stated that the appellant's deportation would have serious adverse effects upon his daughter, there is in fact no earlier statement to that effect beyond the opening sentence of paragraph 58. So whatever the tribunal had in mind, there was clearly sufficient evidence for them to consider that this wasn't simply a case of a father who had little or no involvement with the child, or the child wouldn't be particularly bothered. It wouldn't particularly affect them. They state that there would be serious adverse effects. And we say that the appellant, in this case the respondent, RA, is entitled to know what the tribunal meant of that. And in particular, because that may go to the question of very compelling circumstance and may be quite important, and indeed it may go to the question of unduly harsh. But this isn't. They don't.
Sorry, I'm still struggling to find what evidence there was that was led to support the proposition that there were serious adverse effects upon his daughter.
My Lord, I
We can refer, for example, to the fact that when he was in prison, there was evidence that his daughter would wake at night and ask for him. I mean, that's some evidence, but it would be helpful if you could bring those points out for us, because...
Well, My Lord, it is limited. You know, I mean, there is some comment in the FTT, but that clearly doesn't assist. But my Lord, it's a fair point. But the point being is that if you look at it on the other side, the upper tribunal have clearly formed a view that there are going to be these serious adverse consequences. In light of the evidence, it may be in light of their own views about how such separation and circumstance, in this case, will impact upon this child's emotional well-being. But we don't know because they don't tell us. But they do accept that there are going to be serious adverse consequences. And we say, if they're going to make such a finding in the appellant's, in RA's favour, and in respect of the child, which clearly affects the child's best interests, then following Zumbas, we need to know what those are. Quite plainly, more information could have been put before the upper tribunal, but equally, on the information that was put, it was held that these serious adverse effects arose. And this is also a point that is picked up by Lord Justice Peter Jackson, at at page 372 of paragraph 163. He says, 5 lines down, the upper tribunal's decision itself has little to say about Y's situation beyond the fact that it would be hard but far from unduly harsh. It is said that there would be serious adverse effects on her, but these are not explored. It is said the opportunities to meet may be possible, but that she would clearly miss her father's daily presence in her life. I agree this reasoning is insufficient to underpin the conclusion. It is also interesting to note that whilst the tribunal felt some hesitation about the ghost scenario, it did not feel the same about the stay scenario. Returning to my discussion about emotional harm, it is not possible to understand why it held these differing views about Y's best interests.
Mr. Mazzini, I better point out to you we've got 1 minute left, subject to any arrangement you may make with the other counsel for the respondents.
My Lord, I will try and be brief. We say that the findings on the stay scenario of Lord Justice Underhill were correct, and that the tribunal's approach on this was insufficiently reasoned and arguably contradictory. Finally, in relation to the very compelling circumstances test, at page 366, paragraph 141142, the court's already explored the question of rehabilitation in terms of the legal principle. And at paragraph 143, the Court of Appeal say this: RA's case on rehabilitation amounts simply to the fact that he has not committed any further offence, and there is no reason to believe that he is likely to do. The upper tribunal did not expressly put that fact in the proportionality balance. I think it should have done. The point that the Secretary of State makes in respect of this is that when one looks at the decision of the upper tribunal in RA, although there was no reference at all to rehabilitation when it came to making the assessment, they had discussed the issue of rehabilitation earlier on. We say that's simply not good enough. All that happens in RA, in the upper tribunal, is there is a legal discussion about the impact of rehabilitation. That, of course, is one thing. It's quite another that when they came to actually considering very compelling circumstances, if one looks at page 425 of the upper tribunal's decision, from paragraph 62 onwards, deals with very compelling circumstances, there is not a word about it. There is no finding on whether they accept there has been rehabilitation in this case. There is no finding if they do accept that, what impact it has. And we say that is plainly a material error of law, particularly in circumstances when one stands back and looks at the case and says this is a young man who came here when he was 14. He was put into social services. He was of good character for, as I think you'll see it said at paragraph 101 of the determination. And his offence was at the lowest level, and there is absolutely no suggestion that this is an individual who will ever offend again. So we say that was plainly material error. Finally, on the seriousness of offence issue, this can be found at page 367, and it's paragraphs 146 through to 149, and the important points can be seen here. Paragraph 146. Tribunal notes as countervailing factors that A, the judge gave credit for a guilty plea, and B, that as a sentencing judge pointed out, the offence was a serious one. It was submitted that it was not wrong to treat these points as diminishing such weight as RA could otherwise put on the shortness of the sentence. The Court of Appeal agree in relation to one, the question of the seriousness of the offending should not be discounted because of the guilty plea, and at paragraph 148 they make the point about the seriousness issue which we've already considered. And not only that, but the Court of Appeal note at paragraph 148 that in fact the judge did not say that it was serious. So there was a misdirection in any event as to what the sentencing judge actually said. And these were factors which, again, at paragraph 149, that affected the material consideration of when looking at the proportionality balance. In a nutshell, we say that there were clear errors when they dealt with very compelling circumstances. I obviously accept what this court says about the unduly harsh test on the stay scenario in terms of the evidence, but in any event, we say if you look at the go scenario and the impact that may have on both the stay and the very compelling, and we look at the clear errors and the very compelling, it is inevitable that this matter must go back so that all material factors can be taken into account when considering both the unduly harsh tests and if they fail on that, then those matters found in those exceptions go to the very compelling circumstances. My Lords, unless I can be of further assistance, those are my submissions.
No, thank you very much, Mr. Bazzini.
My Lord, if we can just...
Of course.
Do a little dance and
yes.
Swap over. Thank you.
So you sit to my right and Tony sits to my left. My Lords, I would be hopefully quite short. We do not accept that the respondent, rather the appellant's submission, that the term unduly harsh requires a comparison with a comparator. But if you were to find that the appellant's interpretation of Lord Carnwath's speech at paragraph 23 is the correct interpretation, we would ask you to depart from that for three reasons. First, it's incompatible with Section 55. Second, it's also inconsistent with the case law at this level. And third, it's inconsistent with the ECHR case law. May I take you first to Section 55, which is in the authorities bundle at page 2134. This is Section 55 of the Borders, Citizenship and Immigration Act 2009. Subsection 1, or rather, duty regarding the welfare of children. Subsection 1, the Secretary of State must make arrangements for ensuring that the functions mentioned in subsection 2 are discharged having regard to the need to safeguard and promote the welfare of children who are in the UK, and subparagraph B, we are not concerned with. Subsection 2, the functions referred to in subsection 1 are any function of the Secretary of State in relation to immigration, asylum, or nationality, any function conferred by or by virtue of the Immigration Acts on an immigration officer, general custom functions, C and D are not relevant. So the term functions there, as will be shown in the case law, includes the making of immigration rules. We would respectfully submit first that whilst deportation may fall within the derogation under Article 8.2 under the term prevention of crime and disorder, the protection of the welfare of the children is capable of falling within the derogation in Article 8.2 either for the protection of the health and morals or the protections and the rights of others. Sadly, Article 8.2, I think, hasn't found its way in the legislation bundle, but it's cited in MM, the judgment of this court, which I'll ask you to pick up at tab 21, at page 1183. And if you turn to page 1184, footnote number 2 sets out Article 8.1 and 8.2. And my lords will see that under or after public safety or economic well-being of the country, for the prevention of disorder or crime, being one of the derogations we've identified in discussion, for the protection of health or morals, for the protection of the rights and freedom of others. With reference to health, protection of health and welfare, may I ask you to turn to the judgment of Lord Justice Underhill in HA, paragraph 9, which is, I think, at page 339 or thereabouts, 322, and the last sentence of paragraph 9, His Lordship says that the welfare of children language of the statutes and the best interests of the child language are two formulations which connote the same obligation. And then Lord Justice Peter Jackson, with reference to Section 31 of the Children's Act, paragraph 159, first sentence refers to the health of physical, intellectual, emotional, social, or behavioral developments. So, in terms of the tensions between the immigration derogation, that's preventing crime and disorder, you have an equally position derogation with reference to the protection of the health and morals of the children.
I'm sorry, Mr. Miller, I simply don't understand that point. We're talking there about derogations from the right to family life.
Yeah.
you're concerned to advance the right to family life, not to derogate from it.
Yes, but this...
So the only relevant derogation here is the prevention of disorder or crime, isn't it?
Yes, but in considering the derogation or prevention of crime and disorder, one has to take into account the impact of the immigration deportation decision on the child. And
you do, that's the family life.
Family life. And
yeah, that's the starting point.
Yes, and
not the derogation.
True, but if you are to interfere with family life, and if it does affect the health of a third party, that's the child of the family, then it is only permissible in those circumstances if there is no such affectation, that is, affecting the health and child's well-being. The second submission we make is that Section 55 stands on its own feet, and if I ask you to continue looking at MM, at paragraph 42, in the speech of Lady Hale, sorry, paragraph 46, page 1204, it is the last sentence which I referred to, that the powers under Section 55 refers to the making of immigration rules, and Section 55, it's paragraph 47, reflects what was set out in the Every Child Matters with the 3 bullet points set out there. And before I leave this case, if you please turn to paragraph 92, page 1216. Just above letter F, the duty imposed by Section 5 stands on its own feet as a statutory requirement apart from the HRA or the Convention. And it is our submission that Section 55 is not in any sense modified by Section 117A to Section 117C of Part 5 of the 2002 Act. We also respectfully submit that Section 55 does, as Lord Peter Jackson says in paragraph 157 in HA, that the emotional and psychological harm that a child may suffer is to be given equal importance. And it also our submission that in conducting the proportionality exercise under Article 8.2, the best interests of the child is highly relevant. That is reflected in ZH Tanzania, paragraph 33, at page 1343.
I'm wondering, Mr. De Mello, if this is really in dispute. I'll be corrected, I hope, if I've misunderstood, but I understood the Home Secretary to accept that that in taking decisions in this sort of context, the best interests of children are a primary consideration. Yeah. And I think it was Lord Hodge in Zumbas who said that there's no other consideration that is inherently more important.
Yes. My Lord, I accept that, and but the point I would make with reference to the last feature, if I'll come back to it later with reference to the case of Anwani.
Yes, I think Mr. Pilgerstorff is indicating that he accepts that I've understood the position correctly.
My Lord, whether now or whether by reply, broadly, yes, we accept that position. There was a debate in the Court of Appeal about exception 2 being directed indeed to focus on the interests of the child, and therefore it was the consideration that was going to be considered. When it comes to very compelling circumstances, of course, a primary consideration. It's a well-known relationship.
Yes, I hope that's helpful.
That does, and I could then just concentrate my submissions with reference to the way that the Court of Appeal had interpreted the term unduly harsh. If I ask you to pick up on HA with reference to what Lord Justice Underhill had said with particular regard to the impact of deportation. It's paragraph 84, and Mr. Bazzini had gone through, I think, some of it. It's at paragraph 84, he says that in the fourth line, that will require particular careful examination of the impact on the children, emphasizing Zumbas, and coupled with the way that Lord Justice Peter Jackson addresses it at paragraph 157, indented paragraph, by reference to the approach set out by Lord Justice Sedley. And it's the last sentence which I think Lord Reid had suggested might be the appropriate way, that the balance between its justification and its consequences fall the other way, but whether it does so is a question for an immigration judge. Eventually, these are matters left to the immigration judge to decide as to whether the best interest of the child is of considerable importance, which either answers exception 2, that it forms the unduly harsh meets the unduly harsh test, or whether, as part of the Article 8.2 proportionality exercise, notwithstanding that the tribunal finds that the unduly harsh test is not met, nevertheless goes on to find under Article 8.2 the appeal succeeds. And that is expressed again by Lord Justice Underhill. I think it's in paragraph 30, if I could ask you to pick that up, where he cites NA Pakistan. So just to be absolutely clear in our submission, that the best interest of the child may provide an answer with reference to exception 2, that it's unduly harsh for the child if the father is separated from him, either in the stay or go scenario, but failing which, the best interest is a factor that may have some significance when it comes to deciding where the balance is struck under Article 8. My Lord, I simply state that we without repeating what Mr. Bazzini said, focus on the judgment of the Court of Appeal that no comparator is in fact imported either in Section 55 or in Section 117, C, subparagraph 5, subsection 5. And it focuses on the specific circumstances. The case that we would refer to with reference to the Strasbourg Authority is Unani, and if I could ask you to pick up the authority at tab 16, which is at page, I think, 1042, if I'm not mistaken. Sorry, 761, beg your pardon. The KO Nigeria wasn't referred to when the Fourth Chamber had considered this case, but this was a case where the sentence was 5 years or more. That's paragraph 5 of the judgment, and paragraph 7. The applicant's submission, particularly at paragraph 57, complained about the rigidity of the rules in exception 2. But the government's response to that at paragraph 65 and 66 did emphasize that the rule on unduly harsh was not as rigid as suggested by the applicant, but that all factors could be taken into account for purposes of deciding whether the case succeeded under Article 8. And then the court set out the principles of Bultif at paragraphs 72, which my lords discussed with Mr. Bazzini, that the court should look to the nature and seriousness of the offences committed by the applicant. And then if you turn to paragraph 87, you will also see that not only do they refer, this is the third line, to the length of the sentence, which could be taken into account, but they repeat the Bultif criteria to the nature and circumstances of the criminal offence. But the point to stress is that towards the end of that paragraph, last sentence, that the offence is one factor which has to be weighed in the balance, together with the other Bultif criteria. And at paragraph 89, the point that I draw your attention to is the significant weight accorded to the best interest of the child. And they refer to the seriousness of the offence, to the nature and degree, and that they concluded did not outweigh the best interests of the child so as to justify his expulsion. Coming back to the main theme which I have submitted, Section 55 stands on its own feet. It dovetails with Section 117C, subsection 5. Even if the court concludes the unduly harsh test is not met, it may still go on to consider, for purposes of Article 8, that the best interests of the child, applying the principles in Zumbas, the third proposition, that there is no other factor which outweighs the best interests of the child. So Section 55 plays a part at the first stage when assessing the unduly harsh test, and it also plays a role when it comes to conducting an assessment under Section 80, paragraph 8, subparagraph 1 and subparagraph 2. So, summing up our submissions thus far with reference to Section 55, we respectfully submit that the notion of a notional comparator simply doesn't arise when applying the principles in Section 55 or the case law in Zumbas, particularly the third proposition, and/or taking into account the way that the fourth chamber approached the best interest at paragraph 89 in Unwani. So that wraps up my principal submission why, if you consider that the appellant's interpretation of Lord Carnwath's speech is correct, that is, there's a notional comparator to be identified, we say that's wrong. Can I then move to the second part of my submissions with reference to the facts? The appellant represented himself at the upper tribunal. There was no social worker's report. The upper tribunal took into account the first tribunal's decision, and if you turn to page 397 in the core bundle, paragraph 59, last sentence, they refer specifically to the tribunal's decision, and we respectfully submit that if they do, having found a material error, decide, as they're permitted to do so, to consider the tribunal's findings, then my learned friends cannot criticize us for saying that the Court of Appeal, as well as the Supreme Court, may have regard to the first-tier tribunal's decision to see how those particular paragraphs which are referred to by the upper tribunal are to be read in context. The tribunal's, upper tribunal's decision, page 398, starting from paragraph 68 onwards, they refer to the close and loving relationship with his partner and the children. That entire paragraph is relevant. They refer to paragraph 69 to the emotional and psychological harm which Lord Justice Peter Jackson had considered to be relevant. And they referred paragraph 70 to the fact, last sentence, that his removal would have a significant impact on the children and as well as his partner. And the next paragraph is what we identified as the impugned paragraph, where they made an error, is to refer to the comparator, the notional comparator. At 72, they refer to the difficulties if he's removed about the child care. Then at 75, they again fall in the description of Lord Justice Underhill in that zone where the language used is characterized as a dangerous language. At 78, they refer to the method of communication by separation. And 77 and 78, 77, the difficulties on relocation, and they apply the elevated threshold at paragraph 78. And our submission is mirroring what Lord Justice Underhill says, that if you expunge paragraph 71, that reference to the comparator, and if you expunge paragraph 75, that's the reference to many single parents have the same difficulties, then in our respectful submission, on balance, the upper tribunal should have found in favor of the father in this case. And turning to the judgment of Lord Justice Underhill at paragraph 82, which is at page, I'll just give that to you in a second. Sorry. .349, last sentence. In the context of the primary, it's the last three sentences, but in the context of the primary facts which I've summarized, I think that on balance it is more likely that the tribunal proceeded on a basis that is sufficient to say the situation in HSK is of a kind which is quite commonly encountered in deportation cases. For that reason, I've given that's not the correct approach. They've identified the two paragraphs that I've referred to, which is paragraph 71 and paragraph 75. And Lord Justice Peter Jackson deals to the individual facts commencing at paragraph 160, which is page 370, looking particularly at paragraph 161 on the following page. And that entire paragraph is relevant, but he says that midway, the difficulty with the tribunal's conclusion stated in paragraph 78 is that there is no indication of how primary consideration was given to these children's best interests, and it was not explained how the effective termination of the relationship with their father at least during their childhoods, was outweighed by the public interest in his deportation, it will now be a matter for the tribunal conducting the rehearing to carry out the exercise in the manner described above at para 84. That's Lord Justice Underhill's judgment. But I also respectfully submit, with reference to the upper tribunal's decision on psychological harm, they didn't really engage with it in the way that Lord Justice Peter Jackson stated they ought to, by reference to paragraph 159, first sentence. That's the section 39(1) of the Children's Act. So we respectfully submit that the Court of Appeal was correct in first saying that you don't need a notional comparator. Second, the upper tribunal was incorrect in applying the notional comparator. Third, that the upper tribunal decision was infected by that error. And fourth, it's proper that this case goes back to the upper tribunal with the guidance being applied in the Court of Appeal's decision in the various paragraphs that we've referred to. I also would like, finally, or rather a couple of points, to emphasize, because this is one of the points made by my learned friend, that the facts in HA are no different from KO. And Lord Justice Underhill said at paragraph 83, which is at page 350, midway, or just above midway, that it's wrong to treat KO Nigeria as a factual precedent. And each case has to be considered on its own. I ought to point out that post-KO, there are 3 cases that found its way to Strasbourg, which failed in our domestic courts, but resulted in a settlement with the United Kingdom agreeing with the applicant to pay their costs and grant them 30 months each. The first...
Grant them what, sorry? Grant them...
30 months leave to remain. Yep. They are found in the authorities bundle, and forgive me whilst I find the pages, at tab 12, (1005). There's a second, will you? Sorry?
So what are we supposed to take out of the proposition that somebody settled a case?
Yes, it's simply returning to this question of a factual precedent, and given that my learned friend, as I understood him, to say, look, what are the facts which distinguish ours from those in KO? And if you turn briefly first to tab 12, that's in fact the KO case, which found its way to Strasbourg. It's settled, and one would see on page 1006, paragraph 2, a period of 30 months limited leave to remain in the UK was granted commencing from the date of the settlement. The second case, and in that case, KO, from recollection, received a sentence of 20 months. The next is tab 14. This was a Court of Appeal decision, MA. He was sentenced from memory to 4 or 4.5 years for manslaughter, and my learned friend and I were involved in that case. And this is dated 23rd of September 21. The KO case was dated 3rd of February 22. It led at page 1037 starting at 1036, paragraph 1, he is granted 30 months limited leave to remain in the UK. And second, page 1037, paragraph 4, the government agrees that deportation action shall not be taken against the applicant solely as a result of his previous criminal conviction unless there's a material change of circumstance. And then the final case is MM. That was an upper tribunal decision, and it's dated the same as MA, 23rd of September 21. And I understand he received 24-month sentence. One will see at page 39. On page 1040, he was granted 30 months leave to remain with the payment of cost. And you may ask me, why am I referring to these three cases? And the point being, one, if it's suggested that KO somehow has a factual precedent which may be used as a yardstick to gauge where the balance lies, then at least I'm entitled to say, look here, that's not the end of the story. Strasbourg is sensitive to the government's submissions that the rules are not rigid, that all factors will be taken into account for purposes of assessing Article 8 to see whether the best interests of the child outweighs the criminality and other factors, and the court should be informed of the overall position. I think I have come to the end of my submissions. If I could take stock, just to reiterate what I've said at the outset without repeating what Mr. Bazzini said, which I've adopted his submissions, that if you find that my learned friend's submission on the term unduly harsh as expressed by Lord Carnworth is correct in the way they say it should be construed, then we would invite you to depart from it, because it doesn't fit well with the Section 55 principles. It doesn't fit well with the Zumbas propositions in ZH Tanzania, paragraph 33. It doesn't sit well with the government's own submissions that they made in Unwani that will take into account everything. And it doesn't appear to sit well with the way some of the cases which failed here were successful in settlements and the government agreeing to grant those persons who were deported on grounds of the criminality on the basis that there's a revulsion against foreign criminals, leave to remain. And then there's one final point I should make with reference to HA, and I must confess it's a point which didn't feature in the grounds of appeal. That's a rehabilitation point. He was here for a period of 9 years, whether he was at fault or the government was at fault. It is a relevant factor, which he, of course, would canvass if it's remitted, that he's been of good character. And the point that my learned friend says, that when an early plea is given, and discount is given for an early plea, it somehow should not affect the computation of the length of sentence for purposes of deciding where the person fits in within the first under 4 years and above 4 years is not a proper submission to make, because the sentencing process does recognize that someone who pleads guilty at an early stage will be given credit, and that credit should pass on in the deportation context.
But that doesn't reflect on the seriousness of the offence.
That is true, and so we then have a fallback. Of course, you're allowed to look at the nature and the seriousness of the offence together with any other mitigating factors that I can't escape from. Yeah. I think those are the end of my submissions. I've not said very much about Section 39(1) of the Children's Act, but you can see how it fits in within the context of Section 55, which refers to the welfare, unless I can assist you further.
Thank you very much, Mr. de Mello. Well, that might be a convenient point for the court to rise for a short time, and we'll resume in 5 to 10 minutes. Yes, Mr. Lemur.
Lord, I appear for the respondent AA before you. I adopt the written and oral submissions of my learned friends, Mr. Bazzini and Mr. de Mello, as regards the unduly harsh issue, and I also continue to rely on our written case in that regard. In terms of the time that I have, I'm proposing to deal with two main issues. First of all, whether the Court of Appeal in AA was correct to hold that the first-tier tribunal was entitled, when concluding that the very compelling circumstances test was met, to attach weight to AA's rehabilitation in his favour. And that is issue 8, and I'll call that the rehabilitation issue. And secondly, whether the first-tier tribunal was rationally entitled to reach its conclusions, allowing AA's appeal, whether or not the court agrees with the Secretary of State's contended approach to the unduly harsh and rehabilitation issues. And that is effectively the second half of issue 7 and also issue 9. So, my Lord, I'm going to turn first to rehabilitation. Our primary submission is twofold. Firstly, that the Court of Appeal's analysis of the issue in HA and RA as was adopted by the Court of Appeal in AA, was correct. Now I'm very conscious that my learned friend Mr Bazzini has taken you to a degree to HA and RA, and I don't propose, as you want me to draw your attention to that again, but it's paragraphs 141 and 142 of the analysis. And as you are aware, the Court of Appeal concluded that positive evidence of rehabilitation and thus of a reduced risk of reoffending cannot be excluded from the proportionality assessment, but it can carry some weight in the balance. The weight will vary, but it will rarely be of great weight, as the public interest in deportation is not only based on protection of the public, but wider public interests of deterrence and public concern. But the idea that rehabilitation will do no more than show an individual has returned to the place society expects them to be does not properly reflect why rehabilitation is relevant in this context. So that's my first primary submission. The Court of Appeal's analysis is correct. And secondly, in AA's case, the Court of Appeal was right to conclude, and I'll give you the references to the paragraphs, and I'll come on to it later. So it's paragraphs 39 to 40 of the Court of Appeal's judgment in AA, which is 387 of the bundle. And the Court was right to conclude that AA was most unlikely to reoffend, and that factor should have some weight in the assessment of the public interest in his deportation, and consequently as to whether or not there were, in his case, very compelling circumstances to outweigh the public interest in his deportation. The headlines of the Secretary of State's position are that rehabilitation can be relevant to a very compelling circumstances test, but that when it comes to weight, it will generally be of little or no material assistance to someone seeking to overcome the very compelling circumstances test, because, says the Secretary of State, as explained by the upper tribunal in RA, it does no more than involve returning a person to the place society expects him to be. Thus, says the Secretary of State, the upper tribunal approach in RA, which was adopted in Bimbuga, should be followed, and of course the analysis of the Court of Appeal in HA and RA should be rejected. It is notable that this is a shift in emphasis from the way in which the case was put before the Court of Appeal in AA. And in an AA, in which prior to the judgment in HA and RA, the Secretary of State contended that rehabilitation can never be a factor of significant weight when considering the very compelling circumstances test. And you'll see that at paragraph 39 of the Court of Appeal's decision, which is at page 387 of the bundle, with their reference to the submissions of Mr Malik, who appeared below. It's the first two lines, you'll see there. The Secretary of State's use now of generally as opposed to never necessarily means that there will be some cases where rehabilitation will carry significant or material weight, albeit the Secretary of State has failed to identify in what sort of cases those would be.
Sorry, I'm just trying to orientate myself. I understood the appellant to be saying that the only issue in relation to AA was whether or not the first-tier tribunal's decision was correctly or incorrectly set aside by the upper tribunal, and that there was no appeal from the upper tribunal's decision.
No, there was. So the case was allowed by the first-tier tribunal. The appeal was allowed. The upper tribunal concluded that the decision was effectively perverse on an error of law decision, and went on in a separate decision to redetermine the case and to dismiss AA's appeal.
But I understood that there was no appeal from the remade decision.
No, there was no appeal from the remade decision, but the appeal... Well, actually, there was an appeal to the remade decision as well, and that was dismissed. That element was dismissed by the Court of Appeal. But what succeeded before the Court of Appeal in AA's case was the challenge to the error of law decision. So, on the basis that the upper tribunal was wrong to conclude that the first-tier tribunal's decision was perverse, that there was no basis on which for them to set it aside.
But I'd understood that the issue before us did not involve any analysis of the remade decision of the upper tribunal.
I'm not seeking. I apologise. I've given that impression, but that was. I'm no point in my submissions are going to make any reference to that remade upper tribunal decision at all.
I think what you're picking up on is this, right? That at least in the Secretary of State's written case, he said that the first-tier tribunal was wrong in law because it attached significant weight to rehabilitation, and that was an error of law.
Well, yes, I mean, that's what the Secretary of State...
And your answer is no, it's not an error of law, because once you've accepted that it's a matter of weight, then it's up to them how much weight they give it.
Quite right. And the way, in fact, actually, I think they now express it in the written case. One of the things they say is it's considerable weight. Now, might be semantics, but that suggests more than even material weight. And certainly we would submit that whilst it's not impossible for a first-tier tribunal to attach considerable weight, that isn't actually what happened in this case. It was one of the factors that the first-tier tribunal judge took into account in an overall evaluative assessment.
It's really rather an important point of principle here. There's no point Parliament setting up expert tribunals if appellate courts are going to review their decisions on the merits. And so the traditional approach is that you, is exactly as Lord Leggett just put it, that you decide as a matter of law whether a consideration is material or not. But if it is, how much weight is attached to it is a matter for the tribunal.
Well, I completely agree with that. I don't take any issue with that. And of course, that's the point.
Subject to the limitations of reasonableness. And that would, if it were perverse to attach enormous weight to something which in reality was of not much importance, then that would be a basis for interfering.
Well, my Lord, I completely agree with that. And that was the mainstay and the main thrust of the case before the Courts of Appeal, that this was a prime example of a case where there was a very well-drafted first-tier tribunal decision, which simply there was no proper basis to interfere with. And, of course, what happened was HA and RA hadn't been drafted at that point, but of course, in terms of the reasoning, the Court of Appeal in AA then took on board those additional points of principle which came up in relation to unduly harsh. But I don't seek to demur at all from what you say about that. I mean, I'm going to deal with that in a little bit more detail when I deal with disposal in a moment, but I'm just going to canter through what I have to say about rehabilitation. And I will reach a point, my Lords, when I do ask you whether or not you want me to take you through a variety of different cases, which you may say, well, you don't have no need to be taken through them. But I'll just proceed for a moment and to explain why the difference in emphasis in cases on rehabilitation is important. It's important first because there is a material distinction in my submission, albeit not enormous, between the Secretary of State's formulation, which appears to be generally little or no material assistance, and the rarely great weight formulation. And in my submission, rarely great weight does not exclude rehabilitation from regularly having some material weight in the very compelling circumstances assessment. And secondly, if the Secretary of State's approach is correct as to the rationale behind the limited weight afforded to rehabilitation, the broad range of factors which play into the assessment as to whether someone has rehabilitated in the sense of constituting a low risk of reoffending in the future may readily be discounted from having any material impact when applying the very compelling circumstances test, since they may all simply be categorised as returning the individual to the default position of being a law-abiding citizen. Conversely, if the approach of the Court of Appeal in HA and RA, and indeed AA, is correct, those factors will not so readily be discounted, since there will be matters which are recognised as potentially reducing the chances of reoffending and thus impacting on one aspect of the public interest in deportation, namely, as we've discussed repeatedly, protection of the public from further offending. Now, my Lords, in order to demonstrate why the Court of Appeal's approach in HA and RA and AA should be upheld, I had intended to do three things, but I'm conscious of sort of not reinventing the wheel. So, well, the three things were this. Firstly, I was going to briefly address what was said by the upper tribunal in RA and the Court of Appeal in Bimbuga. Then I was going to draw attention to the Strasbourg and domestic authorities, which established that rehabilitation as a relevant factor which reduces the public interest in deportation. And finally, I was going to address the authorities referred to in RA and deal with why the Court of Appeal was correct to conclude that they do not provide any support for the RA Bimbuga approach. Lord, I might just give you the headlines, and if you want me to sort of take you in more detail into some of those matters, then obviously if you give me that indication, that would be good. So just on the first,
fairly self-evident that one of the main reasons for why it's in the public interest to deport people is because that they're going to commit more crimes, and if there's evidence to suggest that they're not, then that interest is lessened. Well, it's a very simple proposition, really.
Well, my Lord, again, completely accept that. And then perhaps just on that point, in relation to Bimbuga, which recites the Upper Tribunal's case, Upper Tribunal's judgment in RA, if we just have a look at that very briefly, and that's at 949 of the bundle. And it's paragraph 84. And you've already looked at where paragraph 84 then recites what is said by the Upper Tribunal on RA, and our submission in brief in relation to that passage. Of course, we should know, I should probably just say this, of course, in Bimbuga, the Court of Appeal was considering a large number of issues arising from Mr. Bimbuga's proposed deportation. And this is just one of the issues that was discussed by the Court of Appeal in Bimbuga, and it's clear that having recited or cited the Upper Tribunal's decision in RA, there isn't any further analysis beyond that. But in my submission in relation to this passage, the passage that's cited fails to have any regard to the many authorities which include the individual's conduct since release from prison as a factor to be considered when undertaking the assessment of proportionality of deportation. And as my Lord Legate just indicated, it's inconsistent. Well, first of all, it's inconsistent with the authorities it cites, and in particular contains no recognition of the fact that, as just mentioned a moment ago, the protection of the public from further offending constitutes one aspect of the public interest in deportation. So, my Lord, I think that's probably all I need to say about that passage cited in Bimbuga. On the authorities, as was discussed yesterday, there is a consistent line of Strasbourg and domestic authority which identifies an individual's conduct since release from prison as a factor to be considered when making an assessment of the proportionality of deportation. Now, I'm not going to take you to all of those again. We've looked already at Bultif and Unuain, and you have the references in our written case at paragraphs 61 to 62 of the written case, which is 299 of the electronic bundle. But the key proposition in my submission to be derived from a consideration of those cases, in addition to the fact that obviously they set out this consistent authority that it is a relevant factor, is further that in none of those cases, in none of those authorities is it suggested that whilst relevant, the assessment of whether or not someone is likely to commit further offences would normally have no material weight. So that is the Strasbourg authorities, which I said are cited at 61 to 62 of our written case. We also, in our written case, address three domestic authorities of the Court of Appeal, and those are NA Pakistan, the case of Forrester, and the case of CI Nigeria. And again, in my submission, domestically, rehabilitation has been found to be relevant to reducing the public interest in deportation, without any suggestion that as a matter of generality, little or no material weight should be given to it, and without any reference to rehabilitation simply returning individuals to the society, the position society expects them to be in. Suppose I was going to take you to those three domestic authorities, and I'm quite happy to do so unless you indicate the... Well, I will. Okay, so dealing with them chronologically and briefly. First of all, NA Pakistan, which is tab 45 of the authorities bundle. The court, having assessed various matters of principle, then sought to determine the individual cases before it, The relevant passages start at paragraph 99, which is 1656 of the bundle, and that is where the Court of Appeal deals with the case of the individual appellant MY. Starts at paragraph 99, and the court was considering whether a decision of the upper tribunal to allow MY's appeal against deportation should be allowed. The upper tribunal had concluded that whilst MY could not satisfy either of the statutory exceptions, he was able to demonstrate the existence of very compelling circumstances which rendered his deportation disproportionate. And then, that's by way of general introduction, at paragraph 112 over the page at 1658, and this is just around about G on the report, the Court of Appeal notes that in...
Sorry, what paragraph?
Sorry, paragraph 112, and that's at 1658. It's the penultimate page of the report. And this is around about G on the report. The Court of Appeal notes that in reaching the conclusion, the upper tribunal placed reliance on a number of factors, including materially, just under G, the absence of any risk of reoffending. And then the Court of Appeal goes on at paragraph 113 to endorse the upper tribunal's approach. You'll see that first two lines, concluding that it had applied the correct legal test and had regard to the relevant considerations. So that's NA Pakistan. Then we have Forrester, which is tab 34 of the authorities bundle. I'll take you to the relevant paragraph in a minute. This was, like AA's case, a challenge to a decision of the upper tribunal, which had set aside a decision of the first-tier tribunal, which had allowed Mr. Forrester's deportation appeal. Mr. Forrester had been sentenced to 4 years for possession of Class A drugs with intent to supply, and so, like AA in the present case, was unable to succeed unless he could show the requisite very compelling circumstances. And at paragraph 12 of the judgment, when this is at 1488 of the electronic bundle, Sir Patrick Elias, first of all, goes on to cite the first-tier tribunal judge's decision, paragraph 36 from his decision. You'll see that in the indented paragraph at 1488. And it's notable there that there is reference to, just above the quoted passage, Mr. Forrester had shown genuine remorse and proper appreciation of his wrongdoing. And then at the next paragraph down, there is a further citation from the first-tier tribunal judge's conclusion at paragraph 38 of the first-tier tribunal judge's conclusion. And it's helpful to have a look at that because the passage starts on bottom of 1488, and then it's looking at the various factors that the judge had considered, and then goes on to 1489, the other side of the page, to talk about, and this is 4 lines up from the bottom, and the exceptional evidence of remorse and rehabilitation as one of the factors that have been taken into account. And the judge saying this last point removes one significant element, namely the protection of the public, although it does not impact on the other public interest elements, namely deterrence and marking social revulsion. So, of course, that mirrors the arguments that have been made and discussed for this court yesterday and today. Importantly, and of note, at paragraph 21, just on the other side of the page at 1490, the Court of Appeal records counsel for the Secretary of State as saying, accepting that if paragraphs 38 and 39 were to be read together, there was nothing wrong with the judge's approach and no material misdirection. The suggestion there that the Secretary of State takes no issue with the analysis of the first-tier tribunal judge, and I just pointed out to you, cited at paragraph 13 of the judgment. And then finally, at paragraph 22, just over the page at 1491, the Court of Appeal accepted the first-tier tribunal judge's approach and its reliance and his reliance on evidence as to the appellant's remorse and rehabilitation. So, my Lord, that's Forrester. And then finally, there's CI Nigeria, which is tab 32 of the authorities bundle. And notably, that is a case which postdates Binbuga in the Court of Appeal. And I'm just going to refer you to 2 paragraphs in that case at 116 and 119, and that is at 1474 of the electronic bundle and 1475 of the electronic bundle. At paragraph 116, my Lord Legate notes that there were 3 matters to which the upper tribunal had failed to give proper weight. You see that just at the bottom. And then it goes through those factors and deals with the 3rd factor at paragraph 119 of the judgment, and finds that the upper tribunal had erred when considering whether there were very compelling circumstances in not considering CI's lack of offending since the age of 20, and with further resonance to the current case, that the offending needed to be seen in the context of abuse and neglect experienced during his childhood. So, my Lord, again, this is another example of an acceptance of the relevance of the absence of reoffending without any reference to the matters relied upon by the upper tribunal in RA. Well, I was then going to, and again, I don't know if the court want me to do this or not, I was then going to go through the 3 authorities that are referred to by the upper tribunal in RA, which are SE Zimbabwe, DANSO, and LG. And the headline of my submission was simply going to be that they don't provide any support for the conclusion that the upper tribunal in RA purports to derive from them. Now, that analysis was set out by the Court of Appeal in HA and RA, but again, I'm happy to go through those shortly with the court, unless the court doesn't want me to do so.
Do you summarise this in your written case?
Yes, we do. Yes, we do. You have that in our written case at paragraph 63 to 65, and that's at page 300 to 301.
Yes. Yes. Well, I mean, obviously, it's a matter for you how you present your submissions, but unless there's something in particular you think we need to see, my impression at first sight, anyway, is that having a summary of the relevant authorities is probably going to be sufficient, rather than going to each individual case to find much the same sort of thing said in different words. Indeed.
So, Merle, then just drawing the strands together on this element of my submissions, it is well established that the public interest in deportation has different dimensions. I recognise, obviously, we have comments earlier today, of course, reference back to OH Serbia, I think it was, where Lord Wilson, what was Lord Justice Wilson at the time, referred to 3 elements, including public revulsion, and there is a question of as to whether that is an appropriate element of the public interest to be taken into account. But I would agree with my learned friend, Mr. Bazzini, that perhaps today, or these proceedings are not the proceedings to address that, because you haven't heard detailed argument from the parties on it. But regardless, even if there are less than 3 dimensions to the public interest, in fact, perhaps if there are 2, it further strengthens the point that the absence of reoffending and rehabilitation is relevant, because it reduces that aspect of the public interest in deportation. That doesn't mean that rehabilitation will inevitably be a factor which regularly has great weight afforded to it, since, as a matter of principle, it only operates to reduce one of the aspects of the public interest in deportation. Further, the idea that the relevance of rehabilitation relates to the provision of credit for being law-abiding features nowhere in any of the authorities, and in my submission is a proposition insofar as it has any impact on the way in which a tribunal determines a case, it should be rejected. And further still, the reference to rehabilitation as involving no more than returning an individual to the place society expects them to be risks a decision-maker too readily dismissing rehabilitation as a factor relevant in the consideration of the proportionality of an individual's deportation. And my Lord, just as a final point on this, all of that is further consistent with the Court of Appeal's subsequent analysis of the issue in a case called Jallow, which is at tab 36 of the authorities bundle. It doesn't add anything in terms of the analysis, but it adopts and further explains HA and RA, and I'll just give you the references for your notes. It's paragraphs 28 and 29, which are 1511 of the bundle, and paragraph 35, which is 1513 of the bundle. Just one final point in terms of conclusion on the general point. It is notable that yesterday the Secretary of State appeared to place reliance on the accepted high threshold imposed by the very compelling circumstances test, and contended that since rehabilitation will not be given great weight, it would not assist an individual in meeting that test. That argument, in my submission, of course, ignores the fact that, as in AA's own case, rehabilitation will be just one of a number of factors considered cumulatively in order to ascertain whether the high test that is provided by very compelling circumstances is surmounted. So, my Lord, having addressed those general issues, I can then address in short order the question as to whether, in AA's particular case, the Court of Appeal was right to conclude that the first-tier tribunal was correct to attach weight to AA's rehabilitation in his favour. And the key passages I referred to briefly before are paragraphs 39 to 40 of the Court of Appeal's judgment, and that is at page 387 of the bundle. And, my Lords, I make 2 points. The first point is that the Court of Appeal correctly directed itself, in line with the HARA judgment and the line of Strasbourg and domestic authorities that I've reviewed, that an assessment that an individual is unlikely to reoffend is a factor that can carry some weight, although it will not carry great weight on its own, and that rehabilitation is not only limited to the absence of offending since release, it is the risk of further offending more generally that's relevant, and that, of course, is something to be assessed taking into account a multitude of factors. The second point is, and this is specifically in reference to paragraph 40, paragraph 40, top 4 lines, the factual findings of the first-tier tribunal judge in this case, based as they were on the circumstances of the appellant when offending, his steps after release to rehabilitate himself, his changed family circumstances, and his own evidence of his current attitude towards his offending, entitled the judge to conclude that he was most unlikely to reoffend and to treat that as having some weight in the assessment of whether there were very compelling circumstances outweighing the public interest in deportation. And then further down, about 6 or 7 lines up from the bottom of paragraph 40, the court start in a passage which starts, the first-tier tribunal judge in this case has formed that evaluative exercise. The Court of Appeal expressly approves the evaluative exercise undertaken by the judge in reaching the conclusion that AA was most unlikely to reoffend in the future. The Secretary of State has not sought to impugn either the first-tier tribunal's assessment in that regard, or indeed the Court of Appeal's approval of that assessment. My Lords, in my submission, in light of the Court of Appeal's correct approach to the relevance of rehabilitation, and the unchallenged finding that the first-tier tribunal was right to conclude that AA was most unlikely to reoffend in the future, the Court of Appeal was equally right to conclude that the first-tier tribunal was entitled to attach weight to AA's rehabilitation in his favour. So, my Lords, that addresses what I've described as the rehabilitation issue. I was then going to turn to the disposal issue. Now, my Lords, as my learned friend correctly pointed out, out yesterday, AA's case is distinct from that of HA and RA. AA succeeded in the first-tier tribunal. That decision was overturned by the upper tribunal in its error of law decision, and that upper tribunal error of law decision was in turn overturned by the Court of Appeal. Accordingly, if the Court of Appeal was indeed correct to overturn the upper tribunal's decision, the first-tier tribunal's determination will be reinstated, and AA will succeed in his deportation appeal. If this court concludes that the Court of Appeal was correct on both the rehabilitation and the undue harshness issues, our primary submission is that the Court of Appeal's decision should stand. It is, however, our understanding of the Secretary of State's case that they maintain that even if the Court of Appeal was right on those two main issues, that the Court of Appeal's decision would still be flawed, since the first-tier tribunal's determination on analysis cannot rationally have satisfied the very compelling circumstances test. We contend that on consideration that is not a submission that can properly be made out. It is further our contention that even if this court finds in favour of the Secretary of State on one or both of the unduly harsh or the rehabilitation issues, the upper tribunal was not entitled to set aside the first-tier tribunal decision as perverse, since even applying the Secretary of State's contended approaches, the first-tier tribunal's decision in the case of AA was sustainable. So, my Lords, I make 6 points on the disposal issue. First, as is well recognised, and of course this has been said repeatedly in this court over the last 2 days, and was restated by the Court of Appeal in UT Sri Lanka, and that was in itself was recited by the Court of Appeal in its judgment in AA, the upper tribunal is not entitled to remake the decision of the first-tier tribunal simply because it disagrees with it or it thinks it can produce a better one. As a consequence, the reasons given for finding an error of law really matter. I'm not going to give you each of the individual citations for those propositions, but they are set out at paragraph 32 of the Court of Appeal's judgment in AA, in terms of reciting again what was said in UT Sri Lanka. Further, appellate courts should not rush to find misdirections simply because they would have reached a different decision themselves, particularly where the issue is one faced by immigration judges on a daily basis. And regard should be had to the common knowledge of immigration judges. Endless citation of dicta should be avoided in favour of more analysis of the balancing exercise on the facts. That's the first point. The second point, and as a consequence, whilst the first-tier tribunal judgment in AA was reached prior to the judgments in KO and Binbuga, provided it can be shown that the first-tier tribunal applied the correct statutory test, even if the result might be said to be generous, provided it's not perverse, the first-tier tribunal's decision should stand, and there was no need for a specific self-direction. And that specific point was addressed by Lord Carnwath in KO itself at paragraph 43, which is at page 892 of the bundle. And he does that with reference to citation of this court's decision, also in the case of MM11. Third, and contrary to the implicit suggestion at paragraph 119 of the Secretary of State's written case, the absence of a challenge in this court to the upper tribunal's remade decision is of no relevance to the matters your lordships need to determine. The absence of a challenge does not equate to an acceptance of the factual findings and assessments made in the remade decision. It's simply an acknowledgement that different judges may reach different conclusions on the same facts. The focus for this court, as we discussed earlier, is on the error of law decision. Fourth, in the Court of Appeal, AA's case was argued orally prior to the decision in HA and RA without any reference to the current debate as to whether a normative standard should be applied to the unduly harsh test. And as you can see from paragraph 27 of the Court of Appeal's judgment, it was expressly argued on AA's behalf that the first-tier tribunal judge's findings featured a number of matters specific to the family circumstances which did go beyond that normative standard. So submissions before the Court of Appeal were actually made on the basis of the Secretary of State's contended approach before this court today. You'll see, as I said, you'll see that at paragraph 27 of the judgment at 384 of the bundle. The fifth point is that AA received a sentence of 4.5 years, and so, as an individual in the serious offender category, in order to succeed in his deportation appeal, he needed to satisfy the very compelling circumstances test. That said, of course, the fact that the sentence he received was at the bottom of the serious offender category range is relevant when considering whether he had demonstrated very compelling circumstances sufficient to outweigh the public interest in his deportation. And the sixth point is that when looking at the first-tier tribunal's decision, there can be no doubt that the judge correctly recognised that as regards AA's level of offending, and this is, you'll see this at page 493 of the bundle, which is a reference to paragraph 62 of the first-tier tribunal judge's determination. You'll see that there's no doubt that the judge recognised, first of all, that AA fell within the serious offender category, such that it was not sufficient for him simply to meet the unduly harsh test. That, and then you see it's the first line at 62, there is no doubt that the appellant's conviction is a very serious one, and that the judge further recognises a few lines down towards the middle that this is a substantial sentence, having gone through in detail exactly what it was that the AA had been convicted of. And further, in addition to recognising the level of offending, the judge correctly recognised the strength of the public interest in the deportation in AA's case, and that significant weight should be given to the public interest in his deportation. Further describing the public interest in AA's deportation as significant. And you can see that both at paragraph 64 of the determination, which is at 494 of the bundle, just over the page. Taken together with the nature of the offence and the potential harm to the community, I place significant weight on the public interest in deportation. And right at the end of the decision, in the concluding paragraph at 81, which is 497 of the bundle, having considered all of the factors, I find the appellant's particular circumstances are very compelling over and above the exceptions to deportation, such as that they outweigh the significant public interest in deportation. So it's quite clear that the judge correctly recognises the strength of the public interest in AA's deportation when reaching the conclusions that she did. So, my Lords, having addressed those general points, I'm then just going to deal with, first of all, the way in which unduly harsh was addressed, and then rehabilitation, and then that will be the end of my submissions. So, dealing with the treatment of unduly harsh by the first-tier tribunal, it is important to note at the outset that the upper tribunal's error of law decision was premised on the first-tier tribunal having reached a perverse conclusion on the unduly harsh issue, and not on the basis that the first-tier tribunal had misdirected itself to the correct legal test, nor on the basis that the factual findings which underpinned the unduly harsh conclusion were erroneously reached. I don't think that's in dispute, but I'll just give you the references to the Court of Appeal's conclusions on that. So you first of all got, in terms of it being the basis being perversity, which was the basis of the upper tribunal's conclusion. That's at paragraph 31 of the Court of Appeal's findings, where it references paragraphs 37 and 50 of the upper tribunal's error of law decision. Paragraph 31 of the Court of Appeal is 385 of the bundle. And on the misdirection element, you've also got paragraph 34 of the Court of Appeal's findings, which is at 385 of the bundle. At paragraph 34, the Court of Appeal explains that whilst KO Nigeria had not been determined at the time of the first-tier tribunal decision, MK Sierra Leone, of course, had been determined. That experienced judges in specialist tribunals should be taken to be aware of the relevant authorities, and it wasn't incumbent on the judge to have expressly referred to MK in the absence of any indication she was unaware of it, but that actually beyond that, and you'll see this referenced over the page at 386 of the bundle, the first-tier tribunal judge had before her AA's skeleton argument in the first-tier tribunal, and that is a skeleton argument which she expressly refers to having read in her determination, at paragraphs 32 and 34 of her decision, which for your note is 174 of the bundle. And I don't think there's any dispute about this. The skeleton argument expressly referred to the case of MAB, which in turn was a case which replicated the MK Sierra Leone criteria. So there can be no suggestion that the judge was not aware of the elevated threshold. On analysis in my submission, the matters on which the first-tier tribunal relied rationally support the conclusion on the unduly harsh issue, both that the Secretary of State's baseline level of harshness has been exceeded, if that's the approach the court decides is the correct approach, and that AA's deportation would be unduly harsh in the particular circumstances of his children and indeed his partner, if the court applies the approach suggested by the respondents and indeed following HA and RA. The matters relied upon by the first-tier tribunal are summarised in our written case at paragraph 88, which is pages 306 to 307 of the bundle. And I've given you, in each of those, the paragraphs of the determination which covers it. So we have AA's daughter being 12 and being at a key stage of physical and educational development as she moves into adolescence. The accepted expert evidence as to the negative impact on her sexual development and behaviour in girls growing up without a father. The accepted negative impact on the daughter's behaviour and educational achievement when AA was in prison. The accepted, this is over the page, this is D, the accepted negative impact on the socio-emotional development of AA's son. If you want me to take you, I can take you to the actual first-tier tribunal decision where those bits are covered. I just took you to the written case because I just thought it would be marginally quicker, but if you'd like me to pause.
I think, sorry to anything else that may be said, speaking for myself, I'd be content for you to take us to the written case, and if we want to follow up the references, we can do that.
Yeah, because otherwise it just take longer and a bit more fiddly to go through that. Yeah. So, E, the significant weight afforded to the impact that AA's deportation would have upon the relationship between his two children from different mothers, the significant impact on AA's partner's ability to continue to work as a nurse, the impact on AA's son's ability to continue to participate in a number of educational, non-educational, extracurricular activities in light of his suspected special educational needs, the medical condition of AA's partner, which entailed debilitating physical symptoms, which prevented her from caring for their son and necessitated an enhanced caring role from AA, those difficulties being likely to be exacerbated on the birth of her, at that time, expected child. and AA's partner's limited ability to support her son's substantial emotional needs in light of her own emotional instability. In my submission, it's plain that a number of those factors clearly identify matters beyond what would be described as the normal consequences, if indeed it's possible to do that, of deportation for any child. And the matters in particular I would rely on in that regard are the impact that the deportation would have on the relationship between the two children living with separate mothers, the impact on the son's ability to continue to participate in extracurricular activities in light of his suspected special needs, and the limited ability of AA's partner to care for their son without AA in light of her medical conditions, which gave rise to debilitating physical symptoms. Now, my Lords, the Secretary of State at paragraphs 113 and 114 of her written case argues that the matters identified at paragraph 41 of the Upper Tribunal's error of law decision were not sufficient to meet its contended construction of the unduly harsh test. Paragraph 41 of the Upper Tribunal's error of law decision is at 461 of the bundle. But, my Lords, that point was addressed by the Court of Appeal specifically. And the Court of Appeal accepted, now I know you're looking at paragraph 41, so I'll just give you the reference to the Court of Appeal where it addresses this. This is at paragraph 38 of the Court of Appeal's judgment in AA, which is 386. But the headlines are, the Court of Appeal accepted that the Upper Tribunal's paragraph 41 summary was materially deficient, not accurately or fairly summarising the first-tier tribunal's factual findings, and did not take them at their highest, despite purporting to do so. So that point falls in light of the problems with paragraph 41 of the Upper Tribunal's error of law decision. And in particular, it is notable that that passage fails to make any reference to AA's role in the ongoing relationship between his two children from different mothers, no reference to the debilitating effects of his partner's health conditions, which impacted on her caring role, or on AA's caring role and her ability to care for her son, and no reference to the particular learning needs or suspected learning needs of the son. So in sum, therefore, in my submission, the first-tier tribunal's findings on the unduly harsh issue was such that applying either approach to the unduly harsh issue, the first-tier tribunal was rationally entitled to conclude that AA's deportation would have an unduly harsh impact on his children and indeed on AA's partner, because those were the conclusions. Having identified no error of law, the Upper Tribunal was not entitled to reopen that conclusion to set aside the determination. And Lords, finally, I turn to dealing with the treatment of rehabilitation and more generally whether the very compelling circumstances test had been met. Two initial points should be highlighted. First, the Upper Tribunal found no error in the first-tier tribunal's application of the very compelling circumstances test, beyond its consideration of the unduly harsh issue, which obviously was relevant to the very compelling circumstances test. Secondly, in particular, in its error of law decision, the Upper Tribunal accepted both that it was legitimate for the first-tier tribunal to have had regard to the risk of reoffending when considering the very compelling circumstances issue, and you will see that at paragraph 33 of the Upper Tribunal's error of law decision, which is at 460 of the bundle. And you'll see at 460, at paragraph 33, just under the reference to Carey, the Carey case in this court, where Lord Wilson indicated it would be legitimate to consider the risk of reoffending amongst other factors when considering the issue of very compelling circumstances. Insofar as the first-tier tribunal judge may have taken account of the claimant having been raped, and this being part of the context in which he offended, we consider that, in principle, she was entitled to take this into account when considering the risk of reoffending. Whilst it may be of limited weight given the multidimensional aspects of the public interest in deporting foreign criminals, low risk is relevant to one of those aspects. And at the bottom, accordingly, we do not consider the first-tier tribunal necessary to have erred in this respect. So, adopting very much the same arguments that have been put before the tribunal, before the Supreme Court over the last couple of days, the upper tribunal rejects any suggestion there was anything wrong with what the first-tier tribunal did with rehabilitation, and that point is further made at paragraph 47 of the upper tribunal's error of law judgment, which we can see at page 463 of the bundle. Paragraph 47. Although, of course, the judge was entitled to take into account factors such as lack of offending since release, as the judge herself observes at 62, there are other considerations which weigh in favour of the public interest, such as the nature of the offence and the harm caused to society by drugs. The Secretary of State makes 2 points. First, that the first-tier tribunal had not appreciated the exceptionally high threshold imposed by the very compelling circumstances test. That's paragraph 115 of her written case. And that the first-tier tribunal had erroneously attached considerable weight to AA's lack of further offending and rehabilitation. And, my Lords, I'll take those points in turn. As regards the apparent failure to have regard to the relevant threshold, in fact, the first-tier tribunal judge repeatedly referred to both the statutory test and the strength of the public interest in AA's deportation. I've given you the references to that just a moment ago, so I won't repeat those. And indeed, the upper tribunal in the error of law decision expressly rejected any suggestion that the first-tier tribunal had not had due regard to the public interest. But beyond that, the first-tier tribunal judge further self-directed herself in terms of the guidance to the very compelling circumstances test set out in NA Pakistan. And you will see that at paragraph 60 of the determination, which is at page 492 of the bundle, where you'll see there, starting at 492 and then on to 493, there is citation from paragraph 37 of NA. This, in my submission, is of particular importance because, as your Lordships will see from Secretary of State's written case at paragraph 66, her submission that the test sets high threshold is made with reliance on the Court of Appeal's judgment in NA. The first-tier tribunal judge was thus plainly aware of the guidance set out in that case, including, of course, the applicable high threshold, as is made clear by her own self-direction in relation to NA at paragraph 60. In my submission, in those circumstances, it was not necessary for the judge to go beyond that and to expressly self-direct herself as to the fact that the very compelling circumstances test imposed an exceptionally high threshold. It should, as an experienced first-tier tribunal judge, the court should assume that she was aware of that and is aided in reaching that conclusion by the fact that she actually quotes from the case which refers to that high threshold in any event. The Secretary of State's further reliance, paragraph 115 of her written case, upon the upper tribunal's conclusion in its error of law decision that the matters set out, and this is again another reference to paragraph 41 of the error of law decision. So it was referred to in the context of the unduly harsh test, but the Secretary of State then makes the same point again in relation to very compelling circumstances, saying, well, the upper tribunal error of law decision concluded that at its highest the circumstances didn't meet the very high bar. But again, if the same point is made, paragraph 41 of the upper tribunal error of law decision was flawed because it didn't properly set out all of the factors which were relied upon on AA's behalf, and certainly did not treat them and take them at their highest. So then finally turning to the treatment of rehabilitation specifically. Now, even on the Secretary of State's own contended approach before this court that rehabilitation will not ordinarily bear material weight, The first-tier tribunal's approach to the very compelling circumstances test and rehabilitation was rationally open to it, since the formulation adopted by the Secretary of State does not exclude the possibility of rehabilitation being afforded material weight. It just concludes, even on the Secretary of State's case, that it won't do so in the normal run of cases. In my submission, the first-tier tribunal judge provided cogent reasons on which it was open to her to rely as to why rehabilitation was given material weight in AA's case. It is clear that it wasn't simply being said that AA's lack of reoffending since his release would materially weigh in his favour. And it would be helpful now if we just turn up the last 2 pages of the first-tier tribunal judge's determination, and you'll see that at 496 and 497. I'll be making reference to those pages for the duration of my submissions. So the very final passage, which is paragraph 81, this is where the judge draws everything together. And we looked at the first bit earlier, having reiterated the fact that this is very significant offending, and then concluding that the AA was able to meet the very compelling circumstances test. The judge, 4 lines up from the bottom, refers to the various things and refers to various factors, including the appellant's personal background and the contribution made to his offending. This summary was a reference to the matters set out at paragraphs 78 and 79 above of the determination, which included his early abandonment in the United Kingdom by his mother at the age of 11, his suffering physical abuse at the hands of his uncle. This is paragraphs 78 and 79. So 81 is a one-line summary of what's further up on that page. The sexual abuse suffered from a football coach and the very significant impact that subsequently had on him. And then you'll see this more at 79, his consequential vulnerability to the influence of an older male at the time of the relevant offences. So the personal background is one matter that the first-tier tribunal has regard to when deciding whether or not rehabilitation should be given weight. And also the judge relies on the change in AA's circumstances since his offending, which supported her conclusion that future offending would be most unlikely. And that is a factor that was addressed in more detail at paragraph 80 of the determination, just above 81. And she talks about their AA living with his pregnant partner and son, his partner's employment as a nurse and their stable family life together, and makes the point that all of that is in strict contrast to the life he was living at the time of his offending. I mean, Lord, in my submission, those 2 factors provide ample justification for the judge to have given material weight to rehabilitation when making the overall assessment as to whether or not the very compelling circumstances test was met. Finally, I deal with the Secretary of State's contention in her written case, paragraph 116, that the first-tier tribunal judge gave considerable weight to AA's rehabilitation. In my submission, that's not an accurate analysis of the decision. Instead, what the judge properly did was to conduct a broad evaluative exercise taking into account a range of factors which included AA's rehabilitation, all of which were relied upon in support of the conclusion that the very compelling circumstances test had been met. And again, we can see that from paragraph 81 of the determination. The factors that were relied upon were the conclusion that AA's deportation would have an unduly harsh effect on both his children and his partner, in accordance with the statutory exceptions. In particular, the judge places reliance on the fact that the deportation would impact upon the ability of the 2 children to have a continued relationship with one another in his absence. And that is a factor that the judge specifically gave significant weight, and you'll see that at paragraph 72 back over the page, where she specifically refers to that as a factor I give significant weight. And of course, that's important because whilst this factor is something which comes within the statutory exceptions, it has been recognised in NA Pakistan that you can have factors which fit within the exceptions, but which are factors of such force so as to assist in satisfying the very compelling circumstances test. And this was a factor which the judge rationally concluded was something, whilst within the exception, was of particular importance. Another way of talking about that is there's a formulation you would have seen in the written cases which came from Lord Justice Underhill in JG Jamaica, which talks about extra unduly harsh. So can you show stuff within the exception which shows it's particularly harsh? And that was a factor which in my submission the judge was entitled to conclude was particularly harsh when dealing with the unduly harsh exception. And then in addition to that, the judge also has regard, in my submission quite properly, to AA's personal background, the private life he'd built up in the UK since 1999, and all of the other matters, the abandonment by his mother, the physical abuse from his uncle, and the sexual abuse by his football coach. And finally concluding and looking at the impact and contribution that that personal background had made to his offending. So, my lords, drawing all of that together, taking into account A, the significant public interest in deporting those in the serious offender category, and B, all of the factors identified a moment ago, the first-tier tribunal was plainly rationally entitled to conclude that the very compelling circumstances test had been met, even on the Secretary of State's contended approach. And it follows in my submission that there is no basis on which it can be said that the first-tier tribunal decision was perverse, and that therefore the upper tribunal was wrong in law to set it aside, which means the first-tier tribunal determination should stand. And Lords, unless I can assist you further, those are my submissions.
Thank you very much, Mr. Lemur.
Oh, yes. Well, Lords, I should just be completely accurate.
Yes.
I said I referred to the Court of Appeal in AA's case as allowing the appeal in relation to the error of law decision. And there was a second argument that was made about, in the remade decision, about whether it was right to use the phrase very harsh. And the Court of Appeal actually concluded they didn't need to deal with that because we're dealing with the error of law decision. So it's not accurate for me to have said they dismissed ground 2. They didn't actually dismiss ground 2. They didn't have to get onto it.
Yes. Thank you for clarifying that. Yes, Mr. Pilgersdorfer.
My Lords, thank you. I thought I'd start by way of reply and dealing with the question that my Lord, Lord Reid raised on the question of unlawfulness, just to give that answer in case it's helpful and material to your deliberations. That, of course, arises in connection with section 117B, subsection 4, where little weight is given to private life or a relationship established by a person when a person is in the UK unlawfully. That's 985 of the bundle. Of course, that's independent from subsection 5, where little weight is given to immigration. Little weight is given where the immigration status is precarious, where there's a bright line rule that this court has set down that there's a precarious immigration status at any stage where somebody doesn't have indefinite leave to remain. And the reference for your note to that is paragraph 44 of Rupiah at 910. So the question is, what does unlawful mean in the context of section 117B4? And there's some assistance that the court might find in the judgment of Akinyemi, which is in the authorities bundle. And perhaps I can pick it up at page 1399. Sorry, forgive me. You'll see under the heading of ground 1 at the bottom of that, at the foot of that page, you can see that there were submissions from Mr. Drabble about the central concepts in the system being leave to enter, leave to remain. And over the page, at the bottom, paragraph 37, there is a citation from the House of Lords decision in Chief Adjudication Officer and VOLCA. And in the judgment of Lord Hoffman, there's a neat summary which your Lordship might find of assistance in dealing with your question. Firstly, he says there, the key concept in UK immigration control is that of having leave to enter the United Kingdom. The Immigration Act provides that a person who is not a British citizen shall not, subject to material exceptions, enter the United Kingdom unless given leave to do so in accordance with this Act. That's section 3(1)(a). So that's the obligation in law not to enter without leave. And he goes on, a person who enters without leave is an illegal entrant. Section 33 may be removed by an immigration officer. I'll come back to that. And if he knowingly enters without leave, he commits a criminal offence. So that's section 24(1)(a). So there's the criminal obligation. I said I'd add to the removal question. Since that judgment in 2014, further section was added to the Immigration and Asylum Act 1999. I should say I've brought along for your Lordships copies of section 24 that I've just referred to, and this section I'm about to refer to in the 99 Act, section 10, which gives the ability of the Secretary of State administratively to remove if a person requires leave to enter or remain in the UK but does not have it. So that's entering, and then in terms of staying beyond leave to remain, of course, section 3(1)(b) permits a person to be given leave to enter or to remain either on a temporary or indefinite basis, and by subsection 3 of the Immigration Act, conditions can be attached to that. And as Lord Hoffman goes on to explain in the extract from VOLCA, if a person with this is at the top of 1401, a person with limited leave who overstays or fails to observe a condition is liable to deportation, section 35(a). That's on the basis it's conducive.
Sorry, you're reading from?
I'm sorry, from the top of page 1401.
Yes, thank you.
And it's from the extract. It's the second part of the extract from Lord Hoffman's judgment in the VOLCA case. So it's near letter B. So that's a reference to the ability to deport on conducive grounds. Added to that is also section 10 of the Immigration Act 1999, since that decision. And we have, as I say, we have those copies, which I'll hand up at lunchtime for you. And he goes on to say, of course, section 24(1)(b), if done knowingly, a criminal offence. Now, Akinyemi was a bit of a strange factual situation in that, well, perhaps not strange, but peculiar and not relevant to these cases, in that you see at the top of page 1400, Mr. Akinyemi had been born in the country, never required, therefore, leave to enter, nor did he require leave to remain. He couldn't be subjected to leave under those provisions that I've just referred to. But importantly for your Lordship's question, on page 1402, Lord Justice Underhill, between paragraphs 40 and 42, addresses the question of what lawfully means for the purposes of section 117(b)(4. And what he identifies there is the meaning of the language in this is reading from paragraph 40. The meaning of the language in that subsection is not to be found by following decisions on the effect of cognate, though not identical, language in other statutes. The question is whether reference in this particular context to a person being in the UK unlawfully is to their presence being in breach of the UK law, or merely to their not having a positive vested right of residence. In my view, the former construction is correct for two reasons. And the two reasons are, first, as a matter of the ordinary use of language, unnatural to describe a person's presence as unlawful when there's no specific legal obligation of which they're in breach by being here, and no legal right to remove them. And at 42, secondly, a construction which focuses on removability rather than a positive right to remain is more in keeping with the statutory context. Now, in all of the cases before the court today, the individuals weren't born in the UK, and if I take them in turn, HA's case, there was a precarious immigration status throughout. He required leave to enter, didn't have it, and so was present unlawfully and was subject to the removal powers throughout that period, and therefore unlawful on this approach to that word, the word unlawfully. RA, again, precarious status throughout. In terms of lawfulness, required leave to enter, didn't have it initially, so there was a period of unlawfulness. He did have leave, he did have periods of leave that was granted, and his position in the United Kingdom won't have been unlawful during those periods, but materially, during the period he met his wife, underwent his Islamic marriage and then legal marriage, that was during a period when he didn't have such leave and therefore was unlawful adopting this approach to section 117b4. And in AA's case, similar analysis to RA, but it appears in his case, in terms of when his relationship was formed, it was formed during a period of validity of his residence card, so not unlawful in his case. I hope that
yes, that's very helpful. Thank you.
Helps with the answer to that question. So moving then to the other arguments, and I wish to briefly return to my primary argument on the unduly harsh point. We base our primary contentions on unduly harsh on the unanimous judgment of the Supreme Court in KO. The Supreme Court there was expressly seeking to provide a definitive interpretation of what unduly harsh means. And my learned friends say that there's nothing in the statute that requires a comparison, but it was this court's interpretation in KO that the words in the statute, unduly harsh, did imply a comparison by requiring one to compare the effect to what is due. That's inherent in the word undue. And it was in that context that Lord Carnworth, in paragraph 23, invoked the concept of the impact of deportation on any child. We say that that's an important part of his analysis, and it is to be given substantive content. So what is that content? The content, we say, derives from the context. The context is that the law, indeed primary law, an Act of Parliament, declares that the deportation of all foreign criminals is in the public interest. That's section 117C, subsection 1. And that, of course, includes those who are persistently committing crimes or where serious harm results from the crimes. And further, by the UK Borders Act, for those sentences of 1 year or more, the deportation is also automatic and creates a presumption of deportation. So in cases involving family life, there will necessarily be an impact beyond the foreign criminal onto others. So here the statutory context is qualifying partners and qualifying children as defined in section 117D. So the any child concept invoked by Lord Carnworth must be a qualifying child. That, on our argument, imports those statutory characteristics of the definition. I accept that a subsisting and genuine parental relationship has been interpreted widely, and therefore there's a wide spectrum of potentially qualifying children. I didn't mean to suggest yesterday that the definition is limited to those who live with the foreign criminal. I didn't suggest that. What I did suggest is that when thinking about the any child, what Lord Carnworth is likely to have had in mind is a child who has a more material parental relationship with a qualifying child. This follows in my submission from the emphasis that he's placed in the judgment on the extent of the harshness that must be shown. It follows, therefore, he's thinking about a child who lives with or has a material day-to-day relationship with a child, as opposed to, for example, a child whose relationship is built on, say, indirect contract, but would otherwise satisfy the statutory definition. It's only with such a child that a level of harshness of the level described in the Supreme Court's judgment is foreseeable. Hence, when talking about comparators, I suggested, and in a refinement to the written case, a child with whom the foreign criminal was living would amount to a sensible baseline characteristic. And I approached my learned friends' examples in that way. Now, it's that sort of level of harshness that I say Lord Carnworth's test requires to be exceeded. And approached in this way, perhaps, there is no need to describe this as a formal exercise of identifying a comparator, as you might see in an employment case, where specific characteristics are ascribed to a statutory comparator in order to answer the question of whether there's been direct discrimination, for example. Nor is there a need to worry that different first-tier tribunals might make different decisions about the characteristics of such a suitable comparator. One is instead comparing the effect of the index child with the level of harshness that can be expected upon deportation of a parent with a meaningful relationship. That ultimately is what deportation entails, and if I may, with respect, adopt the analogy that my Lord Reid identified yesterday with sentencing, that is, in my submission, perhaps apposite. Because in the same way as sentencing prescribes by law a consequence of the legal offending, then so too the law prescribes deportation as it does. On this approach, I say that the focus remains on the index child, and I don't accept what my learned friends say, that it in some way prevents or distracts from an assessment of the particular child's circumstances. Rather, it's the exercise through which it's determined whether those particular circumstances are enough. My Lords, briefly then on threshold, whatever you make of those submissions concerning the reference to any child in KO, we say it's absolutely clear that that the Supreme Court in KO set out to provide that definitive determination of unduly harsh and underscored the threshold in paragraph 27. The words unduly harsh had caused specialist and senior judges to differ in terms of their approach. But even putting aside that controversy about whether the seriousness of the particular offending was to be excluded from the analysis, you still have to know what harshness is due in order to make a sensible assessment of whether the index harshness is undue. We say that the Supreme Court unanimously and definitively endorsed the description of that threshold at paragraph 27. You have my submissions already that the Court of Appeal effectively lowered that standard. I'm not going to repeat those. But I do say in addition that if the message from the Court of Appeal's judgment to a first-tier tribunal is that whilst it might be helpful to look at the threshold as described in paragraph 27, you won't go wrong if you simply apply the statutory words, then there is a danger. And that danger is that some first-tier tribunals will decide what is due in a different way and perhaps to a lesser standard than that in the threshold. So therefore, whatever else was said in KO, it's my submission that this level of threshold remains high and that first-tier tribunals should be approaching the exercise with that guidance in mind. My Lords, I'll take one further short point on unduly harsh before the lunch break, and that's just really to reiterate and engage with what my learned friend Mr. De Mello is saying about Section 55. As I clarified at the time, there's a well-developed jurisprudence on Section 55 and the approach to best interests as a primary consideration. I reiterate, as the Court of Appeal found paragraph 55, there's no problem with implementing that in terms of unduly harsh, because the impact is on the child in any event, and on very compelling circumstances, I accept it, the best interest must be a primary consideration. What section 55 doesn't do, however, and this may be trite, is give any substantive right to a particular level of harshness that should not be endured. My Lords, in the remainder of my submission, I propose very briefly to address some points on very compelling circumstances and a couple of points that my learned friends have raised on the individual disposal, but perhaps I might do that at 2 o'clock.
Yes. Well, thank you very much. We'll adjourn now and resume at 2.